The state assault weapons ban just got completely demolished. And what happened next will shock every Second Amendment supporter in America. A federal judge made a ruling so groundbreaking that it's sending panic through every anti-gun politician nationwide. But here's the shocking truth nobody saw coming. If you care about protecting your constitutional rights from government tyranny, hit that subscribe button right now, because this ruling changes the entire legal landscape forever. The explosive federal court decision that shattered anti-gun laws. The statistics are mind-blowing. Over 15 million commonly owned semi-automatic firearms were suddenly declared illegal contraband when the state implemented their ban in March 2023. Law-abiding citizens faced impossible choices: surrender their legally purchased property, face felony prosecution with 20 years in prison, or flee to constitutional states. The anti-gun coalition estimated this would remove over $2 billion worth of firearms from civilian hands, while criminalizing hundreds of thousands of peaceful Americans. But then, something extraordinary happened that sent shockwaves through the legal system. On August 15, 2025, federal judge Patricia Williams issued a 47-page decision that completely eviscerated the state's entire legal framework. The constitutional firestorm spreading across federal courts. Most gun owners heard about the Williams decision, but few realize there are actually 23 separate federal challenges to assault weapons bans currently pending across 9 different circuit courts. The Fourth Circuit alone contains 7 different cases covering Maryland, Virginia, and Delaware bans, each representing tens of thousands of affected gun owners. The Ninth Circuit houses 6 major challenges spanning California, Washington, and Oregon restrictions, while district courts in New York, Connecticut, and Massachusetts have issued conflicting stays, creating enforcement chaos. What makes this particularly explosive is that federal courts had been waiting for definitive Supreme Court guidance on assault weapon regulations since the Bruen decision. This created a legal powder keg where over 200,000 individual plaintiffs across multiple jurisdictions were stuck in constitutional limbo, unable to exercise their Second Amendment rights. Court records show plaintiff legal teams have spent over $25 million in attorney fees fighting these bans collectively. The judge's devastating historical analysis that destroys gun control arguments. The historical evidence Judge Williams cited in her opinion goes far beyond typical Second Amendment analysis. She documented proof that destroys every modern argument for assault weapon bans. In her 14-page historical section, the judge didn't just reference colonial-era firearms. She presented evidence that assault weapon features were specifically common and preferred by civilian militiamen during the founding era. Legal historians provided testimony that detachable magazines, pistol grips, and adjustable stocks were standard features on civilian firearms throughout the 18th and 19th centuries, with zero regulations. The judge explicitly stated that semi-automatic firing capability represents the technical evolution of founding-era rapid-fire mechanisms that civilians routinely possessed for both militia service and personal defense. This represents the first federal court to officially declare that modern sporting rifles are the direct technological descendants of constitutionally protected founding-era arms. Even more devastating, she found that capacity restrictions lack any historical precedent, as founding-era civilians routinely possessed firearms, with reload capabilities limited only by available technology. Court records show this historical analysis was supported by over 400 pages of documented evidence from 15 different historical experts. The hidden legal strategy that could topple federal firearms laws. Judge Williams's ruling contains a legal time bomb that few constitutional scholars have noticed. She established a procedural framework that makes federal assault weapon legislation constitutionally impossible under current Supreme Court precedent. The decision specifically found that any firearm regulation must demonstrate a historical analog from the founding era. But more importantly, She ruled that common use analysis must include nationwide civilian ownership patterns, not just local or state-level statistics. This means federal courts must now consider that AR-15 platform rifles are among the most commonly owned firearms in America, with over 20 million in civilian hands nationwide. The judge's analysis goes further, establishing that militia utility is a constitutionally protected characteristic that cannot be regulated away through feature bans or capacity restrictions. She explicitly stated that firearms suitable for militia service receive heightened constitutional protection as they serve the dual purpose of individual defense and collective security envisioned by the founders. This creates a legal standard where any firearm capable of military or law enforcement use automatically qualifies for constitutional protection when owned by civilians. The rapid timeline for constitutional cascade and political panic. Federal appellate procedures reveal that this constitutional framework could reach the Supreme Court within 14 months, while simultaneously invalidating gun control laws across multiple circuits. The state has already filed emergency appeals to the Circuit Court, but legal experts note their arguments directly contradict Supreme Court precedent established in Bruin and Heller. The Circuit Court must rule within 90 days on expedited appeals, and if they uphold Judge Williams's decision, it creates binding precedent across 6 states containing over 75 million Americans. Meanwhile, the 22 other pending cases are already filing motions to adopt Williams's constitutional framework in their jurisdictions. Supreme Court procedure allows for expedited review when circuit courts conflict on major constitutional questions, meaning this case could reach the highest court by December 2026. Legal scholars note that the current Supreme Court composition shows strong support for expansive Second Amendment interpretations, making it likely they would affirm and expand Williams' reasoning nationally. Internal federal documents reveal desperate government response plans. Freedom of Information Act requests have uncovered internal Department of Justice strategy documents that reveal federal agencies are in full panic mode over the constitutional implications of the Williams decision. Internal DOJ memos from August 2025 describe the ruling as an existential threat to federal firearms regulation authority that could eliminate agency enforcement capabilities across multiple statutory frameworks. Strategy documents outline emergency legal responses, including attempts to limit the ruling's precedential value through jurisdictional challenges and procedural appeals. Federal agencies are reportedly developing enforcement priority matrices that would focus resources on non-constitutional violations while avoiding cases that could reach the Supreme Court. The documents reveal that ATF leadership is privately acknowledging that current regulatory frameworks cannot survive strict constitutional scrutiny under expanding Second Amendment jurisprudence. Internal presentations project potential loss of 60 to 80% of current enforcement authority if Williams' framework becomes national precedent. Federal prosecutors are being advised to avoid cases involving commonly owned semi-automatic firearms to prevent adverse Supreme Court rulings. The constitutional truth that exposes decades of government overreach. The devastating reality that government lawyers don't want to admit is that virtually all modern federal firearms regulations violate the original understanding of the Second Amendment, making the Williams decision just the beginning of a complete constitutional restoration. Constitutional research reveals that the Founding Fathers intended the Second Amendment to protect civilian access to military-grade weapons, specifically to maintain the balance of power between government and citizens. Historical documents show that colonial civilians routinely owned cannons, warships, and rapid-fire weapons without any government registration or restriction. The Second Amendment's "shall not be infringed" language was deliberately absolute, designed to prevent exactly the kind of incremental restrictions that have accumulated over the past 90 years. Legal scholars note that if federal courts consistently applied original constitutional meaning, the entire regulatory framework from 1934 to present would collapse overnight, restoring full civilian access to all small arms regardless of firing rate, capacity, or military utility. This victory represents the beginning of a complete constitutional restoration that will return firearms freedom to its founding-era scope. Your rights depend on understanding these critical legal developments that mainstream media actively suppresses. If this analysis opened your eyes to the constitutional revolution underway, subscribe immediately and share this with every patriot you know. Because together, we're witnessing the collapse of tyrannical government overreach and the restoration of constitutional liberty.